happened. Again, I would suggest to the Court that all of the cases that have been cited by my opponent are fraud in the inducement cases. They're all cases involving embezzlers. They're all cases involving people who were in some way, shape, or form put in that position because the deed or the instrument or the transaction was a transaction that they were involved in, they were a party to. And certainly, if you're a party to a transaction, that is where you protect yourself, because who else is better able to protect themselves than the person who is in the transaction themselves? Why do we want to exempt a bank from having to do proper due diligence? Big case, small case, whatever it is. Why shouldn't they do due diligence? It seems to me like that is a reasonable thing to expect. And I would suggest that there is case law, perhaps not in this jurisdiction, but in other jurisdictions, which support that. And I would suggest, McNary versus Baxter, Bankruptcy Court decision from the District of Columbia, Judge Teal, very ably understood this principle. As between the lender and the person whose signature is forged, the lender is the one taking the business risk that the notary public had acted improperly, or that the notary public has himself been defrauded by, for example, the presentation by the forger of fake identification documentation. The person whose signature is forged is an innocent party and ought not to have the deed of trust given effect. In that case, in McNary versus Baxter, the Court took a very common sense approach. And it is an approach that's common sense, Your Honor, because really what we're arguing about is, will the title insurer have to pay this claim? That's actually what we're talking about here. And the problem is the title insurer does not want to pay this claim. What the title insurance company wants to do is they want to put the risk of loss on a property owner who has absolutely no way of getting title insurance. That makes no sense. That makes no sense. And we as lawyers, we have a tendency sometimes to make things very complicated. But if you were to walk down the street and tell somebody that this happened, and tell them that somehow the bank got a good lien or a good mortgage, I don't think a single person at the mall would say that's possible. They would believe that that is something from a different planet or a different country, but not here. And I think that that is something that we have to also be cognizant of. Just because we don't have case law here that reflects the cultural values that we have, because we've never encountered this, doesn't mean that we have to follow old precedent that isn't exactly on point and that really doesn't address the problem. Because the problem is a serious one. The problem is that you or me, if we have a corporation, could easily walk home one day and find out that we don't own our land anymore. And that is not something, Your Honor, that I think is anything that any of us would want to have happen to anyone. And, Your Honor, if you don't have any other questions, I think I will sit down.
Thank you all.